Welcome to From Students to Licensed Professionals, Protecting Your Rights.
Welcome to From Students to Licensed Professionals, Protecting Your Rights with attorney James Kosnett. James has represented students, parents, families, and licensed professionals for decades, helping them navigate academic misconduct allegations, expulsions, special education disputes, licensing board complaints, and other high-stakes school issues. I'm Lisa Mosby, and today we're talking about what happens after you respond to a licensing board complaint and how these cases move through the board process. Hi, James. Thank you for joining me again today.
Hey, Lisa. How you doing?
Well, I'm well, thank you. You submit when someone has submitted their response to a licensing board complaint, what does the board usually do with it?
Well, we've, submitted a response. We talked about that in a previous podcast where
Mhm.
how much to say and what to say is something that a lawyer has to weigh in on, because just because you're innocent doesn't mean that you're going to spill all your life story and give them every detail of what happened, because sometimes they'll just turn around and use that against you. But on the other hand, if there's an explanation that will work and save the licensee further time and expense, you want to give them that and get rid of it. So there's a tension there between fully cooperating or cooperating enough to get rid of it. But if they're going to go after you anyway, it's better to give them as little as possible so that you can play those cards in front of the judge when you're ready to, without giving them a lot of advance time to prepare for your defense. So, but we'll take it from the point as your question, where you said you've submitted your response, what to do then. Well, now it's in the hands of the board's investigator and who's ever in charge of discipline at the board. And they will usually either, if they're satisfied that there's nothing there, which is pretty rare, but once in a while it does happen, they'll just dismiss it. Most likely, they're going to move ahead and give it to an attorney, either an attorney on their own staff or someone in the Attorney General's office, a deputy AG. And a deputy attorney general, deputy AG, will prepare what's called an accusation, which is like a complaint in civil court, but this is an administrative complaint. Now it's called an accusation, and it's an agency complaint against the licensed professional, whether it's a doctor, a nurse, a real estate professional, an insurance professional, a teacher, what have you. So they'll prepare this accusation, they'll file it, and they'll serve it on your client at your client's last known address, which is why it's very important for the licensed professionals to always keep a current address with their board. That way, if something goes amiss, they find out about it right away and they have time to react and defend themselves. Then, of course, they should contact the attorney and we take it from there.
And James, how does a licensing matter move from investigation into an accusation, a settlement discussion, or hearing?
Well, we just talked about how it moved on to the accusation stage. Okay. So we can't really penetrate that too much. That's really their decision. You can compare it to the police doing an investigation and deciding there's enough to charge a person with a crime, and they'll talk to the prosecutor, and the prosecutor will issue an indictment or a complaint. So there's not too much involvement by the defendant at that point. That's pretty much on the side of the police and their prosecutor and what they're going to decide to do. Yes, sometimes there is some input, but usually there isn't. You get, not till you are uh, named, charged, and arrested do you begin to defend. So in the administrative context, it's similar. Once you're accused and you've got the accusation, now you can respond. the first thing we do is we request a hearing. And we've usually only got 15 days to get that in. So we always request a hearing, even if we don't really want one, to preserve our right to a hearing. Because you can request a hearing and then decide not to have one, but you can't miss your deadline and then think that you could easily recover and get back in the ball game. It's harder, and it costs more time and money. So you request a hearing. All right. Then what do? We exchange discovery. What's discovery? Discovery is any documents that you have that bear on the matter, various emails, receipts, photographs, letters, your contract with the person who's complaining about you, your billing records, anything that's really relevant to the allegations in the accusation, and anything you want them to see about you. You might want to show them character letters and great evaluations that you've had, and all kinds of positive things about you, volunteer work and charity work, and I usually also have the client polish up their resume and give one of the long version resumes. They used to tell us we need a one-page resume when we're applying for a job because they don't want to read a lot of paperwork, and that's true. But this is not for job application. This is more for make you look as good as possible. Show all the good stuff about you, all your publications or your good works and everything that's in there. So we usually polish up a resume. So we provide them with all of that. They have also provided us with everything they've got. It's interesting because in my field of practice, administrative law, discovery is a lot more efficient, in my opinion, and fast and less costly than in the superior court in the civil cases, where you can get involved in very lengthy, time-consuming, and expensive disputes over what's appropriate to be given and what can be withheld or objected to. And that sometimes is the most expensive part of the case in the beginning. And it could take months sometimes because it has to be set forth in a motion with an opposition or a reply and then a hearing in court. Whereas in administrative law, if you don't give it to them, you can't use it later. So people err on the side of giving everything because you want to be able to use it later. You don't want it to be objected to and kept out because you failed to give it.
Do you have some final advice for our audience today, James?
Yeah. After the discovery stage, we have the settlement. That's when we can talk to our opponent and try to work something out that's either get the case dropped or get a very, very minor kind of warning or a probationary situation that will drop off after a stated period of time, and avoid a suspension or worse, avoid a revocation. So we always try to do that, and we engage in that negotiation. And if that works, fine. And if it doesn't, then we go to a hearing.
And that's a topic for another conversation on another day. Thank you again so much for your time today.
You're welcome.
Folks, that's it for today's episode of From Students to Licensed Professionals, Protecting Your Rights with James Kosnett. If you're facing a licensing board complaint, investigation, or disciplinary action, visit professionallicensedefense.org to learn more or schedule a free consultation. Thank you so much for listening, and don't forget to subscribe, share, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.